In this tape, we look to discuss some of the more common conditions that occur in medical malpractice. Before we do that, it is important that you understand what the term standard of care means. The law requires that all doctors provide a certain level of medical care quality. This is the standard of care. This legally means that a doctor must provide that level of care ordinarily provided by others in that field under the same or similar circumstances. Note that the law does not require that you receive perfect care, or for that matter, any quality of care above the standard of care. This concept is similar to the legal concept that every person is entitled to a fair trial, but not a perfect trial. Humans just don't operate in the realm of perfection, so as long as the medical care was reasonable, then that is enough. When a doctor is sued for medical malpractice, the suit is alleging that the doctor deviated from or breached the standard of care. When the doctor responds to the suit, the defense will be that the doctor complied with the standard of care. For this reason, an expert witness in medicine is required from both sides to explain to the jury why the standard of care was or wasn't breached. The jury listens to both sides and it gets the final word. The jury decides. Failure to diagnose and timely treat cancer comes up frequently. What happens is that a patient is seeing a doctor for care and at some point is diagnosed with cancer. The patient will oftentimes feel that the doctor should have caught this. This, then, is a failure to diagnose type of case, or malpractice by an act of omission, as discussed in our introductory medical malpractice tape. Let's go through how a case like this gets analyzed by the law. Once the cancer is diagnosed, then the type of cancer it is must be identified, as must the stage of the cancer. The type of cancer tells the characteristics of the cancer and where it is in the body. The stage of the cancer tells how aggressive it is and if it has metastasized, spread to lymph glands and other parts of the body. We then look to see why you were seeing the doctor. If you were going to the doctor for a chronic cough and you ended up being diagnosed with lung cancer, that is a whole different situation than if you were going to the doctor for a gout attack on the big toe and had lung cancer. The point being that in general terms, the law and the jury probably wouldn't think that toe treatment would involve checking the lungs, whereas chronic cough care would. In other words, was the doctor caring for you for a condition which might require checking the cough, which would have resulted in diagnosing the cancer even if by accident, if you will. The next point to be considered would be the length of time that has passed between seeing the doctor and the diagnosis of cancer. If that was a short period of time, then the argument against your case would be that it didn't matter. Clearly, the longer the time, the more chance for the cancer to spread. This is called a causation defense because, as we discussed in the introductory tape, the law requires that the doctor's improper acts directly cause the harm suffered. If it can be shown that the harm was suffered from something else, or that it would have been suffered anyhow, then there is no case. Some other ways your case can be attacked using a causation defense is that the cancer was an extremely aggressive cell type which would have spread in any time frame, or that it was already spread when you were seeing the doctor, or even that the result of treatment would be the same no matter when it was treated. As you are hopefully beginning to understand then, medical malpractice is not an easy job. MedWitness Limited provides the expert upfront analysis of the case that is needed to set it up properly. No one wants to spend the time, money, and aggravation of going through extended and detailed litigation only to lose in the end. The general rule is, no case is better than a bad case. If you truly do not have a case, you're better off abandoning the effort as soon as possible. MedWitness Limited is an expert at making this determination. But although we at MedWitness do not want to try and manufacture a case, neither do we want to miss any detail which may support a case. We can honestly say that if a case does exist, that we will find it. Another common case of omission is failure to timely diagnose and treat angina, leading to a heart attack. It is still sadly the case that in this day and age, some doctors do not recognize some of the less frequent signs and symptoms of heart disease. Once again, however, the same defenses apply in that it must be shown that the doctor had a duty to evaluate for this in the first place, and that any breach of that duty directly caused the heart attack. Once again, if the patient had another condition which caused the heart attack, then things may change. These are always matters of proof. Newborn baby disorder cases resulting from some sort of bad care during pregnancy or delivery are common, and require the client to prove that the child wasn't genetically disposed to the problem or suffered the problem from an unavoidable event. This is a good time to discuss what those are. Medical care is not an exact science, and at times people suffer side effects of some care. For example, if you have neck spine surgery for osteoarthritis of the neck, it is known to medical science that during surgery some damage is going to have to be done to smaller nerves to treat the bigger ones. It can even be that certain errors can occur that come up even in the best surgeon's hands. These types of errors are called unavoidable errors, or also reasonably foreseeable errors. These are not malpractice as they are known to occur about 10% of the time, even when being careful. This is different than a known error. A known error is one that is possible but very rare. It essentially occurs 1% of the time, and so it is considered avoidable. It is the known errors which can be avoided that are malpractice, and not generally the avoidable errors or the reasonably foreseeable errors. Errors in orthopedic spine surgery where the hardware or screws are misplaced and hit a nerve can be malpractice. Falls in the hospital are always malpractice, as are bed sores. Fractures can be set wrong, resulting in loss of proper limb function. Aggressive strep is another modern-day problem, where the doctor fails to timely provide appropriate antibiotics for treatment, resulting in much greater damage to tissue. Failure to warn is commonly an issue. This is where a doctor finds something on or about you and fails to warn you so that you know to do something about it. The doctor should warn you what might happen if you do not follow up in a given time frame. A doctor is required to always provide an honest and complete informed consent. For example, a doctor may be more concerned about financial gain for himself and his hospital than about your well-being. Such a doctor may advise you to have a procedure at his hospital even though his hospital is much less experienced in performing that procedure properly or safely than a nearby hospital. If you get hurt, you may have a case for failure to warn. If your doctor has you go through an unnecessary test or procedure, again, usually related to motivation for financial gain, but also related to ignorance at times, then any complications you have, including unavoidable ones, are then a basis for suit. The logic here is that but for the doctor tricking you into doing something, you would never have needed it or done it, and therefore you should not be prevented from recovering for anything about that procedure. On the other hand, understand that if you were warned about something and ignored the doctor's warnings, then that is on you, and no suit against the doctor is warranted. Also note that something like smoking is so universally known as dangerous that no warning is usually required there. It might be like requiring a doctor to warn you that jumping off a cliff may result in a broken bone. They say that the law has its problems, but that it is not an ass. Some things are so obvious that no expert witness is required to tell us about it. These are a few of the actual conditions commonly seen. We see the myriad of diseases that can occur that should be diagnosed and treated earlier but aren't, as well as many different types of operations gone wrong. It is important to remember for purposes of medical malpractice that patients realize that just because there might be a bad outcome does not automatically mean that something was done wrong. We at MedWitness Limited fully understand this, and our goal is always to review cases with that in mind.